foundation of
recording in progress.
Interruption there. So the foundation of a preliminary report, the starting point for a preliminary report is that search, that title search. We're gathering all the information from the official records, whether it's recorded documents or property tax information, and then information that's within our title plan about properties, so that we can examine the search and put together a preliminary report that's going to be used to facilitate the policy in an escrow closing. And to talk about that a little bit, when a preliminary report is open, it is, or issued rather, it is specific for that transaction. It's not for any other purpose. It's stated right there in the term. So what happens is sometimes people will open an escrow to get information about a property. And if title isn't made aware that it is only an information request, we assume it's an escrow, so a report is going to get generated. But that report is specific for a policy of title insurance on that transaction. So if there isn't a transaction, the preliminary report is not really the right report for that process. Sometimes people need reports for permits, for condition of compliances, for other reasons, and something other than do with title insurance. And we do offer some title products that we can issue for a fee, and those take a little longer, but it is available. So a preliminary report is specifically used for an escrow to facilitate a policy of title insurance. That's really the only point or purpose of a preliminary report. It's not a full representation of the title on a particular property, because there are old documents that we may be eliminating or removing because they don't affect the ability for us to insure the property. For example, an old deed of trust that's been released and removed, we're not going to show that. We're not going to show any documents that have expired or termed out or that have no effect on our ability to insure the title. So it's really just an agreement, if you will. It's what a policy of title insurance is. It's just an agreement between our company and the insured, protecting them against certain title defects and other matters that are contained in the policy. But back to the search process. So once that open order it happens and it comes to us, my team now has to work on that report and get it back into your hands, right? So we have a standing goal that our preliminary reports for resale orders, the typical turn time has always been 3 business days or less. And that is what we strive for in all instances. However, there are other factors that affect it, and it could be volume. When we have a very strong market and a lot of orders, the order volume can impact our ability to service those orders, as well as the type of property involved in the search. So the good thing is, with our company being the largest title insurance company in the world, and the fact that we're the largest here in our county and we have the largest market share, we have written title policies and reports on a lot of properties over the years, not only under Chicago Title, but a lot of our other brands and our companies that we have succeeded, or that we have taken over. So in other words, we have a pretty good database of orders, prior title evidence that we can search from, rather than going back and searching a title all the way back to the patent, or to when California became a state, on every order. If we were doing that on every single order, it would take weeks and weeks for your reports to be processed. So because of these streamlined processes we have behind the scenes, if we have a prior order available to us on that particular order, we can now use that as our starting base. We don't have to go back, like I said. So it may be quicker and easier for us to turn that report out than one that we have never searched before, a property that we never searched. So that's why you'll see some preliminary reports come out in 1 day, 2 days, and 3 days. In fact, I think right now about 90% of our reports do go out in 3 days. But that other 10% take us longer because they're more involved, difficult searches, and they just require more time. And in our industry, we don't have the ability to go out and hire people when we get busy and bring them in, and because it takes months and months, if not years, to train a title examiner to the level of where they can truly understand what they're doing with a title search. Now, because there are different levels of complexity, we have different levels of examiners. So our level 1 examiners, for example, can take the orders that we have prior work on, or that they're simple lot and tract and that they have no complexity to them. Those people can work on those orders and get them out fairly quickly. The second level orders maybe require a little bit more touch, a little bit more expertise. And those are the ones that are going out in definitely within 3 days. But some orders just are more complex, whether it's the property itself or the impact of what the folks who are in title have done over the years. And I'll get into that in a minute, but sometimes people will do some really weird things with their properties, or try doing things themselves, or they'll work even with an attorney who will help them to record things, but they don't understand the impact it could have on their title. And we see some very strange things. But so back to the search process again, to get that report into your hands, it isn't just pull something out of a shelf and send it to you, right? It's a process. It's something that we have to put together and assemble, and then make sure everything is linked and properly formatted, so that when we send it to you to use for your marketing of the property and working with buyers and sellers, you have the product in hand that's what you're expecting. Unfortunately, there are situations where, because human beings are involved, there could be errors in the report. There could be a typographical error, or could be maybe somebody missed a lien, or maybe a deed in the chain of title or something. And it does happen. It's a very, very small percentage of our reports may contain an error. But that's one of the benefits of title insurance, is when we close an escrow and we issue that policy of title insurance, if it is determined that there was an error in our search, or something we failed to show that's going to cause a loss to the insured, well, that's covered. That's the point of title insurance, because when human beings are involved in any process, there's always a propensity for mistakes to be made. So I always like to point that out, because we like to be as perfect as we can be, but we're not. And there are times when a report may have some errors. So that's the process of the preliminary report, going from a open escrow to actually getting in your hands and being used. And then once that report is out there, right, the buyers agents, the seller, they may have questions about what's contained in the report. They may see things there that they don't expect to see. For example, they may have one loan on their property, but they may get the report and see 2 or 3 loans appearing. And it's not uncommon. It's just what happens is the lenders, after someone refinances and pays off an existing loan, sometimes those lenders aren't following through on releasing that lien. They aren't getting that release to the county recorder and getting it of record. So when we encounter that in our search, we have to show any lien that we find that we don't feel we can insure over. So to give you an example of that, we may find an open deed of trust in the chain of title from 10 years ago, but we see that we had insured the next loan, right? The one that paid that one off. We have evidence in our hands. We were the title insurance company that handled that escrow. So we know that that loan was paid off, and we have insured the current lender against that loan. So we're willing to eliminate it. We wouldn't even show that lien in the new report. And behind the scenes, we're going to take steps to try to get that lien removed. We have a recon tracking department that does that very thing. They take every transaction that we close, they follow up to make sure that a lien release is going to get filed, and then they'll send out follow-up correspondence to those lenders. But that's that process. So when the report is in your hands, obviously the best thing to do is look at it, right? Make sure it's the parties that are vested are the people that you're working with, if you're the listing agent, and that there's no surprises in there. There's no requirements for something to be re-recorded, or something to be submitted to title for review before we'll insure, because that's the whole point of the report. Or the purpose of the report is to show the items that we find of record. They're already of record. So there could be liens, there could be easements, there could be restrictions affecting the property. We're going to show those matters because they are already of record, and they would not be covered by a policy of title insurance because they're existing matters. Now, if the buyer and the seller come to an agreement that, certain items they want removed, they're going to have to clear those to our satisfaction before we're willing to eliminate them in the policy of title insurance. Now, for the most part, easements, restrictions, agreements that have been of record, those are not something that's going to be easily removed, and most people would just take subject to those in the purchase. But they're certainly not going to want to take the seller's liens, right? If there's existing property tax liens, if there's IRS liens or state liens or something on the seller, old deeds of trusts, all of those things are going to want to be cleared so that the buyer gets clean marketable title from the seller upon close of escrow. And then we would be issuing the buyer a policy of title insurance and their lender, if they're getting a loan, to protect their interest in the property going forward. So that's pretty much it on the title report, the preliminary report, and getting it from A to Z, if you will. Before we move on and talk about policies and things, I thought perhaps, we could open it up and see if there was any questions on that process or anything that's relative to you.
I have a question.
Sure.
What if there's a line of credit and a zero not show?
I'm sorry, I was having a little trouble hearing that.
A line of credit, if someone has a line of credit and that shows up and it's a zero balance, how does that work?
So that's more of something that, on the escrow side, that would be something they take care of. But my understanding is that they submit a demand to the beneficiary for any loan that's in our report, or, they know that they have to pay off. If that demand comes back as a zero demand with nothing to pay, that's fine. That certainly happens. But part of that process, for our purposes, I believe escrow needs to get a freeze letter, something that says that they are going to, once this escrow closes and the lender gets that evidence of that, they will close that account and freeze the line of credit. Because in the past, what's happened is escrows would close, they would get a demand, they would pay off the balance of those credit lines, and then wait for a reconveyance to come post-closing. Well, title companies started seeing a lot of claims because what was happening, the lenders, especially the large lenders, Wells Fargo, B of A, Citibank, et cetera, they have various departments within their organization, and they have a trigger somewhere, right? If they know that a payoff request is being received for a HELOC, their marketing department may then send out something to those borrowers saying, hey, we've got this product and that product. And we've had instances where even though the lien was paid off, right? The HELOC was paid, the amount was paid zero, paid to, at that point, instead of closing the line of credit, the lenders extended it, right? And borrowers would go take more money out. And, maybe they were paying on it for a while, maybe they weren't. But whenever it got to a point where they stopped paying and it became a foreclosure situation, you can bet that our insured, so we've insured against any of those prior liens, getting notified that their property that they purchased, however long ago, is about to be foreclosed on a prior lien before they ever took title. Now, clearly, that's a covered matter. That's something that we're going to step in and take care of. So in the past a situation where that could happen. Nowadays, because of those claims and the number that happened across all title companies, we're experiencing that. I think our process, and I don't know if Marlene, anybody there has a better explanation as to the escrow process, but my understanding is that all steps will be taken to close that line of credit, freeze it. It can't be used again. So I hope that answers your question.
A question. I have a trust sale, and Dad passed away years ago. Mom recently passed away. Dad's death wasn't recorded, so I had to bring a original death certificate of Mom and Dad to title and a copy of the trust. Well, what happens next on the title side? What do you guys actually do with that? How does it get recorded?
So, okay, well, I'm not sure if I apologize because my audio isn't all that great on this side, but I think if I understood you correctly, you're saying that the title was vested in a mom and dad, trustees of their trust from many years ago. Now, either one or both of them are deceased. Is that what I understood correctly?
Yeah, Mom and Dad are both deceased. The trustee is their son.
Okay.
But so that's not recorded.
Yeah, and so that's a very common issue. So what will happen is the preliminary report will be issued. It's going to vest off of what we find of record, right? So in that situation, if title was vested in John Smith and Jane Smith, trustees of the John and Jane Smith Trust, that's how it's going to show in the preliminary report. Now, in the curative process of closing the escrow, we're going to learn that mom and dad are deceased and the son is now the successor trustee. That's who you signed your listing with, or who you're working with. That's a very common situation. So what happens is escrow will help, or if they have their own attorney working on it, they will prepare an affidavit death of trustee and or an affidavit change of trustee, as the case may be. Now, trusteeships and whoever a trustee is of a trust can change. The trust itself is actually the title holder, but a trustee has to hold title for the trust. So that's why, the mom and dad, or in this case, the husband and wife were the original borrower, original owners. They beat it into their trust. Their trust is the owner. Maybe they're also the beneficiaries of that trust, right? Upon their death or anything that may change, it could be one or both of them is incapacitated. They've been declared incompetent, and so they can no longer act on their own, or they just flat out resign as trustee because they no longer want that duty, and they can therefore assign the successor trustee. All of that is going to be established in their trust documents. So what happens is on the title side, we're going to request, in addition to seeing the trust vesting, we're going to show an exception that says, any loss by reason of their being a trust in title, and then presenting to us a copy of the trust or a certification from the trustee that they in fact have the powers to execute documents. So in this case, we need to establish that the mom and the dad, the original trustors, are deceased. The successor trustee is being purportedly the son. So this affidavit death of trustee would record. It would name, the original deed where they acquired title. It would say that they are now deceased and that the son is now the successor trustee. We can then update our report to vest in the son as successor trustee of the trust, and he would execute the deeds to the buyer, or the deed to the buyer, right? And the escrow documents. And that's how that works.
How long does that
It's really just, there's no probate or anything in that situation like there would be. Let's say if there was no trust, if it was just the mom and dad entitled, and then they died, right? That would be a probate. That's going to take weeks and weeks. They have to go through a legal process, and their estate has to be distributed to their heirs, or a court can order the property be sold, and the executor of the estate would be the one selling it. But if they're in a trust, that's the whole point of that. That's the beauty of a trust, is it avoids that situation. So that document, it's basically a copy of their death certificate, or the original certified copy of their death certificate from the county. This affidavit signed by, in this case, the son would be the one signing it. It would be recorded concurrently with the documents in the close of escrow, or it can be recorded before the close of escrow and the report updated. So, but it's a very quick process.
Fast. That part would be fast. Yeah. But if it's not a trust, that's where it's going to take.
Yeah, they go to probate,
Right.
but it doesn't like delay escrow or
No.
anything.
Yeah, no, sometimes as a follow-up on that, what we see is it was intended to be in their trust, right? Let's say title is vested, the report comes out, it's vested as John Smith and Jane Smith, husband and wife, as community property or something like that. But you're told that, like in this case, the son is the successor trustee of their trust. And it was his understanding that, they were in a trust, and he should be able to sell this. They don't want to have to go through probate now when they have a trust. Now, if they can establish that they had a trust, that they went and created it, it's signed in a valid trust, they just forgot, or maybe they did try and it failed, to record a deed transferring title from themselves to the trust before their death, right? Let's say in a case where they did transfer title to their trust, but because of a defect in the deed, of an incorrect legal description, or they didn't deed out the same way they acquired title, there's various reasons for a deed to fail. But in an instance where if title was intended to be in a trust, and they have their trust that shows the property is a part of their trust, there's a process where they can avoid the full probate. It's called a Hegstead petition. And they have to get an attorney to basically take all their documents to the court and pray and beg the court look, this was intended to be in their trust. You know, it's going to cause harm if we don't have it in their trust. So literally what happens is the judge can order that the property is vested in the trust and the successor trustee has the powers to act. That's all that we need from a title insurance perspective to be able to move on and have the son handle the sale at that point.
You got a hand up?
Jana, if you want to unmute and ask your question, there you go. Unmute
Yeah,
yourself.
unmute yourself. Janet, can you unmute yourself? All right. Talking.
She doesn't know she's not muted.
You're muted. Janet Graham, can you unmute yourself?
Yes,
There you go.
Yay.
okay. You know, I am asking about title and escrow, the departments, there are two departments, right?
Yeah.
And we only deal with the escrow. And how does that interaction works? And if we have only title issues, we just to go to the title department separate?
Well, although there are different departments, in essence, you're working with Chicago Title and you're working with your escrow officer. So truly everything pretty much goes through your escrow officer and the escrow team. There are instances where you can talk directly to a title officer. It may be more beneficial to the situation, and that's something that escrow would arrange with the title officer directly. But same part of the same transaction. Seem to have lost. Oh, there we go. I lost the video for a moment.
You're
I got
good.
it, thanks.
Okay.
Any other questions? Nothing in there? All right, move on.
Okay, so moving on to talking about title policy. So the most common policy that is issued in a real estate transaction involving a sale is going to be the Alta homeowners policy. It's for the last decade plus, it's been the premier policy that's issued in residential real estate transactions. It's only available on 1 to 4 family residences. Typically, we prefer it to be owner occupied and an established property in a subdivision, minimum acreage. You know, I think there's a limit of 5 acres and above. We either have to not offer the Alta homeowners or we have to limit the coverage. And it's because the Alta homeowners policy is so much more enhanced than a regular title policy. It provides coverage for things that are some off-record matters that we have no way of actually confirming prior to the close. So we are willing to give some coverage with deductibles and with a maximum liability coverage. And some of those may be like boundary lines and fence issues. In the CLTA standard policy, which was always the policy of title insurance that was issued in most cases prior to this ALTA homeowners policy, that standard coverage was basically just there's no defects in the title, then no one else can claim an interest other than, you know, the parties that were listed in the report, and that there's no fraud or forgery and things like that. The Alta homeowners policy takes it further than that coverage. It provides for zoning violations, building code violations. We protect against mechanics liens. That's something that's not ever been protected in a standard policy. And so because there's all these enhanced coverages, one of the processes in the closing is we're going to ask the seller to provide an ALTA homeowners affidavit. Basically, if they're aware of any of issues that would affect our coverage, and there's a whole list of these questions that they have, we want to know if they're aware if there's any violations, right? If they are aware of code violations or something built without a permit, the recent work of improvement that could cause mechanics liens. Those are all questions that we want to know before we close. Because we're offering that additional coverage, we have to protect ourselves from putting ourselves in a situation where we have a claim. So if we know there was a recent work of improvement on the property, for example, we have to ask certain questions. We need to know how long ago was that work done? Has everybody been paid? to what extent was the work done? Was a general contractor hired? Were there subcontractors? All of those things matter because there could be, months down the line, someone who is disgruntled, that didn't get paid, or, has a valid lien or a valid claim on the property, could file a lien at the county. And even though the person they contracted with, the seller, is long gone off title, they still have a valid lien on a property. And so at that point, title insurance would have to kick in and protect against it. So we're going to make sure we take steps prior to the close of escrow to ask those questions. We don't want to be in a situation where your buyers are getting notified of someone foreclosing on a lien on their property. That's pretty unsettling, right? I mean, they paid the hundreds of thousands, not millions of dollars for a property, and then a few weeks down the line, they get a notice that someone's trying to take the property from them for an unpaid lien that had nothing to do with them. So we try to take those steps in advance. And again, we're in the business of profit like any company, right? So we need to make sure we're not going to put ourselves in a risk situation. So if we're aware of anything prior to the close of escrow, or if our escrow team becomes aware, we have to ask those questions. And unfortunately, sometimes it can delay the closing, because if we find out 2 days before closing, or even the day of closing, that there was some prior work, we need to have our underwriters approve that closing. And so we're going to have to gather a bunch of information and provide it to them to make sure that they're comfortable enough in insuring over. So if our seller is willing to sign an indemnity that says they'll take care of any liens that come up that they had agreed to pay prior, that is a good way of making us comfortable, right? So that's part of that process. And we have ways of getting us to that closing. But it's always good to make sure we're handling these things well in advance of the closing date, because there's nothing worse than waiting until the day of closing to try to figure out a bunch of issues like that. So, but as far as the coverage in that title or that policy, that is, like I said, it protects not only against some of these, all the standard record issues, but if someone were trying to, let's see, I'm just trying to think of a good claim situation. I've had these come up in the past, but let's say that somebody who used to own the property had reserved some sort of benefit for themselves in a deed. And, let's say that they had reserved an easement in gross. Now that could be where it's not an easement over the property for the benefit of another person. It could be an easement that's for a specific person's use. In other words, it doesn't benefit another property like a neighbor. It wouldn't be a common driveway. Let's just say that over this property, before I sell it, I want to reserve, let's say it's a nice, beautiful property with hiking trails. I want to reserve the right to use the property, twice a year for, whatever. And I put that in writing in the deed. Now, if title didn't pick up that little blurb or that verbiage that's in a deed, it's called a deed restriction, essentially. And we didn't report it in the report. And title or the escrow closes, buyer receives their policy. Months down the line, year down the line, somebody comes on their property and says, hey, I'm here to use my property or use it for that purpose. Now that's a valid claim because it's something that was of record and it was in a document and we failed to show it. So that would be a valid claim. But if it was a situation where it was an off-record matter, let's say that they had a gentleman's agreement with the seller for this purpose and they had established that in years ago, but they've never recorded anything. Now, there's still going to be a claim situation because the buyer is going to say, hey, someone's coming on my property and they're claiming an interest and they're going to submit the claim. Now, whether that's a covered matter under the policy is going to be dictated by by the provisions of the policy. I don't think there's anything in any of our policies that would protect in a situation like that. So that would become a civil matter at that point. They would have to basically sue or prove to that person that they have no interest or no right to use that property because there's nothing recorded. There was no constructive notice providing to the world that they had that right. And any judge would usually agree and they would quiet title in that situation. Now, again, from a title insurance perspective, that probably isn't going to be a covered matter because it's not of record, but we have a duty to defend our insured. So, the moment there's any kind of a litigation or a lawsuit, we have to step in. So even though there's not a covered matter and we don't have to honor a claim, we may have to defend our insured and it's going to cost us some money. And so we try to avoid those things at all costs and try to report everything that we find that could potentially be a claim. I think that's pretty much it on the policies. I have a whole plethora of information. I'm sure I can sit here and talk to you guys all day about a lot of things title related, but I don't know where we are on time, Kevin and Marlene, but I don't know if if you open up to Q&A if you want, or we can talk about some of the actual specific. I got common title problems and red flags that kind of come up in a closing. We can talk about those.
Common problems, stuff that you see every day or every week.
Right. Excuse me. So I don't know if, I think you've handed out some material there. I don't know if one of them is that the brochure on common title problems.
Yes.
That's one of the ones we have there. Like, so obviously there's many title issues that can cause a loss or someone to lose their property. And in fact, this is one of those ones I think it's more relevant because I hear this. I hear whether it's TV ads or radio ads for, I can't remember the name of the company, but it's warning homeowners about how nowadays everything's online, right? All information is out there, especially after the pandemic and everything being forced to be online. Everyone's deed records or information about your property can be found online. And so one of the things that thieves and fraudsters are doing is they're coming up with ways of taking a property that maybe doesn't have a lot of activity, it's been owned for a long time. They will basically get a deed, copy of the original deed or deed of record, and they'll forge the people's signatures and act like they're selling it to themselves, right? And then they'll go and use that deed to open get a loan on the property. They'll take out hundreds of thousands of dollars of loan on the property and then not pay. And what happens is that lender now starts the foreclosure process. And through that whole process, they get a notice on their door that property is going to be sold at auction because of non-payment. And, lo and behold, they're calling their title company, and the title company who insured their title, at that point, there's no coverage for future situations, right? Title insurance covers you from today backwards against defects in the chain of title, against someone in the past coming forward and claiming interest. But we certainly can't protect against some future fraudulent event. If somebody were to take your title and steal it, essentially, there's no coverage for that. So it's one of those situations where people ask, well, how do I find it out? Because there's this company that I saw advertising a service where you pay a fee and they'll check your title every so often for you and alert you if they find a deed recorded against your property. Now, I thought that was a pretty good idea for someone to make some money on that, but it's the same thing that anybody can do themselves if they have the means to do so. You just got to basically go to the county and you can check your property. Now, most people aren't going to do that, right? But anytime you're going through a refinance or you're going to sell a property, that's where we come in and we do the search of that title and we look for that. Now, if we find a deed in the chain of title that is uninsured and it is transferring the title and someone left title without the benefit of what we know is a insured title transaction through a legitimate title company, we're going to call out that deed. We're going to best back to the last good deed, and we're going to call for an affidavit or a declaration to be signed, because that deed stands out to us. It looks to be like it could be, just what we'd like to know is did the person who signed that deed really sign it, right? Because especially if it says a gift of love and affection, no consideration, people don't usually give away property of high value for nothing, right? So even if it is a legit transfer of title, one person transferring it to someone they know, we're still going to question that because we want to make sure that, for one, it is legit, that they did sign the deed, but two, that there's no off-record agreement between them. Let's say maybe they agreed to pay person pay the other, $1 million for this property. And even though they don't have a written lien on the property, there's an expectation there. So we need to ferret out all that information and find out before we're willing to insure over a deed like that in the chain of title. So that's why when we search the title, we're looking at every deed. We're making sure that signatures, to the best of our ability, don't look forged, that it looks like it would be, in the course of a normal transaction. When you see a purchase and then a deed of trust recorded concurrently, a deed and a deed of trust. A few years later, you'll see another deed of trust of record and that old one paid off. That's a refinance, right? That's pretty standard. But when you start seeing deeds from one party to another, back and forth, or, several people being added suddenly and, going away, if it's not handled through a normal process, an escrow process, where it's not stamped with the recording requested by a title company, something that looks legit, we're going to start questioning that and making sure that we're not putting ourselves or our customers in a situation where there could be, some fraudulent activity. So because we're protecting against fraud and forgery, we have to, in some situations, we have to question deeds. We have to ask for more documentation. We have to ask for something from somebody who left title years ago. Sometimes people get angry at us because they seem like, why are you asking for that? What do you need this? But, we're insuring, it's now hundreds of thousands, not millions of dollars in every transaction. We have to make sure that, we keep the profit or the premium that we made, because anytime we have a claim, that affects our profitability there, right? So we're going to make sure we take all those steps. But common title problems, gosh, there's so many of them. Like I said, I can probably speak all day, but some of the more common ones we see: false impersonation of the true owner of the property. I already discussed that. Forged deeds, forged releases is another one. So sometimes we'll see a property will appear free and clear. An order will come in for a refinance, or rather a loan transaction only, right? Property, the report comes out and it shows free and clear. And that's because the liens that we found of record have reconveyances or releases recorded for those. Now, we actually have to look at those releases and make sure we're satisfied that it is legit. There are red flag situations. So let's say there's a purchase and a deed of trust together. And then a few years later, clearly a refinance, a new loan recorded, the reconveyance for the old loan. Maybe 2 or 3 times in the course of the chain of title, that'll happen. But if there's suddenly a release of a deed of trust with no new financing, nothing new, that stands out as a red flag to us. Now, maybe they won the lottery, right? Maybe they own another property and they paid off this loan with proceeds from other properties. That's fine. We just need to ask those questions. So there are situations where we may need to ask escrow to provide us an affidavit from the parties stating that, or in some cases, they actually have to follow up with the lender to make sure that the release that we found was actually recorded by that lender. Because there's been so many claims against title companies for these false or forged releases, especially back after the 08, 09, if a lot of foreclosures were happening, people were forging releases, they were hiring companies that claimed they could get them out of foreclosure. And those companies, what they would do, they would forge a release, basically. They would record a reconveyance for the lender. Let's say it's Wells Fargo. They would record it, not even signing as Wells Fargo. They would just sign as, whoever they were. And unfortunately, because they knew that a lot of title companies in our search process, if our examiner sees a release on a chain, they may not always pull that release. They just see a release, so they move on. So obviously those practices have all been changed because of that. But that was something that was causing a lot of grief for the title companies for a while, because we were paying out a lot of claims on these situations. But undisclosed or missing errors, there might be someone in title that we're showing a vesting for that no one's like, well, they haven't been around forever. What do we do? How do we find them? Unfortunately, we can't help with that situation. We can only report what we find. But if there is somebody who's missing and they can't locate them, they'll probably have to do a quiet title action. They'll have to go to court and they'll have to provide a whole bunch of documentation and evidence and order that person's interest is removed from the title. We would then be able to insure after that order, but not before. There could be mistakes in the documents, like legal description errors. That's something that we see a lot. Just today, I was doing a report where a chain of title report for someone who's going through a process to get a certificate of compliance. And we list all the deeds in a chain of title for a period of time. Well, these people had acquired the property fairly recently from another person, and it was an all-cash purchase for a vacant parcel out on the coast. Didn't pay very much for it, but all of the deeds leading up to the ones that prior to them getting the title, there's about 5 deeds in the chain of title. They all had a legal description error. The name of the map, instead of the map of Granada number 7, it was listed as Granada number 8. And then the book and page of the map was transposed. So 4 or 5, or I think it was 5 deeds in the chain of title were incorrect leading up to the deed where they acquired title. So of course their question when I sent the report was, well, what does this mean for us? You know, and I said, well, you're going to need to find out who, and I don't know if they received title insurance. It wasn't through our company who recorded that deed, but they're going to need to go back and find out if they have a policy, then they can perhaps file a claim on their title policy against any defects because of those deeds in the chain. But I suspect that they just purchased it from somebody off the street, so to speak, and they may have a situation now. But you know, in that situation, the vesting goes back to the last good deed that had a good description. So all those subsequent deeds technically failed to convey any title. So if we were asked to insure that transaction, we would have to vest back 5, 6 owners ago, and that's who the only person we would accept a deed from, right? In a sales situation. So we would have to tell them they're going to need to go to court, do a quiet title action, and make all those deeds good, or get it ordered into their name before we would insure it. But you know, legal description errors, typos in someone's name, you have to deed off title the same way you acquired it. So if someone acquired title with a middle initial or a middle name, and then on the deed where they sold to the buyers, they failed to show that, that could be a failure of title. So those are all things that we have to be cognizant of when we're doing our title search to make sure we vest correctly. Now, it does occur after the close of escrow. The buyer gets a letter from the county that says the deed where you acquired title had a flaw. Either the legal description was wrong, or the sellers were wrong, or something to that effect. Now, that's clearly a situation where they're going to contact usually you, the agent, and or escrow. We look into it and we see what the issue is, and then we're going to take steps to fix it. Sometimes we have to re-record the deed to correct the legal description, or we have to go back and get a deed from someone who had an interest in the title. So, for example, this happened recently. One of our level 1 examiners came across a deed in the chain of title, vested on that deed, showed it on the preliminary report. We closed escrow. That person was the seller to our buyer. Well, it turns out that deed was only representing 50% interest in the property. There was another title holder who already held 50% interest. So now we have a situation where the seller received 100% of the proceeds and was the only one who signed the deed. And so the buyer now only had 50% interest in the property. So in that situation, fortunately for us, the seller and the other title holder were together. They shared the proceeds. It was no problem for us to go and get that deed re-executed with both parties to our buyer, and everything was fine. But you can imagine if in our error of not vesting it correctly and finding out that those parties were not friendly or together or what have you, or just flat out ignored us after the close of escrow. You know, we're going to make the buyer whole, right? We're going to fix it, but you know, we would be paying for that other interest at that point if necessary. So, but those are some common problems that come up.
Can you touch on the marriage? I know that some people get married prior to, during,
Yep.
and then after get divorced. I know that's been a common theme. Some of the closings that we've had. So can you kind of touch on that piece?
Absolutely. So it's a good point, and that was one of the ones that's on the list here: marital rights as of spouses. So if a person acquires title as a married person in California, because of community property laws, their spouse automatically has rights in that property, unless they can establish that it's their separate property. And the only way to do that from our perspective, for a title insurance perspective, is let's say that Kevin's receiving, he's buying a property and he's buying it as a married man, as his sole and separate property. He wants to keep it separate from the community of, the community estate. There would need to be a deed from his spouse to him, relinquishing any and all possible community interest in the property. And that would establish that it's his separate property. That's a very common situation, and it's no problem. What we do see sometimes is someone will be in title as an unmarried person, and then they've never changed the title. It's vested as that person as an unmarried man, unmarried woman. Then we write the report, the report goes out, it shows them in that capacity. Well, through the escrow process, we learn that they're now married, right? They've since become married. So the question is, does the spouse have to also sign the deed to the buyer? Now, because of the way the community property laws are written, if you acquire property prior to marriage, as a single person, as an unmarried person, it remains your separate property if you keep it separate. Now, in a legal world, there's all kinds of things that could cause that property to become part of the community. It's called the transmutation, and commingling of funds is one of those things. Let's say if you pay the property taxes and the mortgage payments out of a community joint checking account, that could be established as transmuting it into community property. But since we deal with title insurance, or title insurance deals with things of record, actual knowledge and constructive knowledge. So unless we know otherwise, unless since the deed established, it was an unmarried person, since became married, now they're deeding out. In our world, we wouldn't need anything from the spouse because they acquired title prior to marriage as their separate property. But if in the process we found out, and again, this is pretty rare, but if the escrow officer, in a conversation with the customer, the agents, said something about, we're making payments on the mortgage out of our joint checking account. If there's some actual knowledge or written knowledge of us knowing its community, we wouldn't have any problem with that. In other words, unless they record something, if they've acquired title as a married person and there's no interspousal deed of record, we absolutely are going to require the spouse to deed off before they'll allow them to sell it because of those community property laws. Now, there are situations where the people aren't, let's say they're going through a divorce and they take the steps after the divorce for one party to deed to the other. It's part of the settlement, right? Suddenly we'll see a deed, John and Smith and Mary Smith, husband and wife, and then it'll be a deed from John Smith to Mary Smith. And, technically that's someone leaving title, and it's not usually through a title company. So that's an uninsured deed. Now we have to ask for that uninsured deed affidavit, right? Because of that situation I explained, it's an uninsured conveyance. Now, in a situation like that, most couples are probably not amicable and not willing to, they've already done their business as far as they're concerned. They've deeded the property to the other person and they've moved on. Now, here we are asking them to go and get that other spouse to sign an affidavit saying that they signed the deed, et cetera. Now, the good thing is we have an alternative method for that. In other words, instead of the affidavit, if they can provide the marital settlement agreement from their divorce that shows the party was to be transferred from John Smith to Mary Smith, something like that, we would waive the affidavit at that point. That would be an okay transfer. We can see why that occurred, right? It was established. But it's situations where a person acquires title, and this has happened, they acquired title as a married person because they're buying it all cash, there's no lender involved, there wouldn't be a requirement at that point for the spouse to sign an interspousal deed. The title company could let that transaction close, and the deed to the buyer will show as a married person. Now, when the next transaction comes up, when they want to sell or refinance, if we encounter a deed that shows they're a married person and there's no interspousal, before they can close or before we'll insure, they need to get a deed from their spouse, right? So they may be delaying something on the purchase, not getting the deed from their spouse at that time, but they're still going to have to get it when they leave title later on. And it can be problematic if there's, a change at that status, if they go through a divorce or something. Because we find that with property values so high in our area that people will sue and claim an interest in a property over the smallest of things, right? Because it's so valuable. And we're a ripe target. Our industry is a ripe target for fraud. Billions of dollars change hands every year, and the thieves know how to implement their, they know our procedures, they know how things work in the title companies with recordings and things like that. So they find ways of overcoming our defenses, right? If we put up, every time we find these new schemes and new scams, we'll put up something to combat it, but they're, sometimes 3 steps ahead of us and they're already working on the next one. So But we get fraud alerts and, claims awareness training. We're constantly on the lookout, and it makes our industry suspicious of the activity that happens in real estate transactions. So we have to be very careful of what we're reviewing. If it looks out of place, if it, so like they say, if it smells funny and, it doesn't fit, probably something wrong with it, and we go with our guts at that point. And we do see, there's clear cases of fraud and forgeries on deeds. We'll call out that situation and say, we're going to vest back to the prior deed, and we're going to call out that deed and say, we want this re-executed in front of our own company notaries, or we'll require something from them, things like that. So.
More questions? Peter, wealth of knowledge. I appreciate taking the time today and doing this for us.
Not a problem.
Great. Appreciate it. Anybody else have any questions? All right. Hey, great job. Thank you very much. And
welcome.
appreciate it.
Thank you all. Have a good day, everybody. Bye now.